Hello and welcome to the fourth week of the Convention of States Michigan Constitution Conversation. Today we are going to be covering the first 10 amendments, also known as the Bill of Rights. We're going to give everyone a few minutes to join us. If you are not familiar with this series, we invite you to go back afterwards and watch the first three segments when we covered the beginning of the Constitution, the meat and bones of it, how our government was set up. That was awesome. You can find it on Facebook. You can find it on YouTube and I believe Instagram, Robin. So you can go back and catch up there. This is a really important conversation for us to be having right now because there's so many conversations nationwide about protecting our Constitution, protecting democracy. What does that mean? And it's hard for us to truly understand what that's all about unless we actually go back and understand the Constitution itself. So thank you for joining us. I want to introduce the panel. Today I'm going to start with Robin because I haven't started with Robin before. Robin, would you please introduce yourself to everyone?
Sure. Good evening, everyone. My name is Robin Riddell. I am the State Communications Coordinator for Convention of States here in Michigan. I have a great team of writers, social media people, videographers, and we create a lot of content to help you become more educated, informed, and engaged. I will be communicating with our online audience. So in a little bit here, I'm going to slip away from the screen and I will be behind the scenes taking care of business there. And I live in the middle of Michigan. I live in Fenton, Michigan, just outside of Flint.
Robin makes the world turn for us. So thank you, Robin. John, you want to introduce yourself?
Sure. My name is John Polstra. I'm the regional captain for Convention of States that covers all of Livingston County and part of Washtenaw and Oakland counties.
Thank you, John, for being here. Tyler, go for it.
Hey everyone, I'm Tyler. I am a district captain out of Troy. I was previously a district captain on the south side of Indianapolis, and glad to be here.
Thank you, Tyler. Don?
Don Regan. I'm on the legislative liaison team, and I'm just live south of Grand Rapids a little bit. Been with Convention of States probably about 10 years now, so just looking forward to it.
Yeah. And we have a special guest with us today. Sean, you want to introduce yourself?
Hi, everybody. I'm Sean. I am Robin's son, and I am here because my mom and I have a lot of conversations about these things. I am a lawyer by trade, and of course, everything I say is not the opinion of the firm that I work for. Thank you.
Nice little disclaimer there.
Yeah, you got to do it. Might not have a job next week otherwise.
Oh, well, if you're just joining us, once again, this is the fifth installment of Convention of States Michigan's Constitutional Conversation. Today we're going through the Bill of Rights, which is the first 10 amendments. So we're going to go ahead and get started. But before we jump into amendment number 1, we're going to turn things over to Don, and Don's going to talk to us a bit about the language that went out to the states when they were going to ratify the amendments. Don, I want to let you take over.
Okay, Jen, just a little bit of a background. So when the Constitution was out for ratification, there was a debate that took place in the newspapers, and you may have heard of the Federalist Papers, the Anti-Federalist Papers. So there's arguments going on back and forth whether or not to ratify. And so the Anti-Federalists brought up some really great arguments, which caused everybody to, consider, all right, what are they talking about? And so this debate went on, and the Federalists brought up a bunch of great arguments in favor of the Constitution. And then Madison ended up, promising that should he make it into Congress, that he will bring up all their concerns from each of the ratifying conventions of the different states and try to formulate a list of amendments, and that they deemed it or dubbed it the Bill of Rights. And so in 1789, when they swore Congress in for the first time, everybody's first term in office, Madison held true to his promise in the summer of '89. He got 2/3 of the House and 2/3 of the Senate to come together for a session of Congress to propose several amendments. So there's 12 of them in total. The first 10 of them ended up getting ratified as part of the Bill of Rights. And so I wanted to call our attention to the preamble that went with these 12 amendments. So once Congress proposed these amendments, they didn't become an amendment right away. They had to get routed to the states. And so they bundled them up, all 12 of them. And with that, they also called out this preamble. And I just want to, it basically reiterated that, Congress got met in New York, because that's where the first seat of government was, because there wasn't a Washington, D.C. back then. And they gave the date. And then he also iterated that the conventions of these states, they had several issues that they were dealing with, and they wanted to add certain amendments to adopt into the Constitution. And the reason they wanted to do that is simply they expressed a desire in order to prevent misconstruction or abuse of its powers. And what they're talking about there is misconstruction. I had to kind of look that up, what they mean by that. Well, that's basically to misconstrue or to just misinterpret the Constitution. And so all the ratifying conventions demanded that, there's be further declaratory and restrictive clauses should be added. And then they also state, as an extending the ground of public confidence in the government. So that's contained in the Bill of Rights, and in the preamble of the Bill of Rights. And I think we just need to dwell on that, as you do your private reading and try to understand what was going on in the minds of these congressmen when they wrote these proposed amendments, because each of the states, again, had to ratify these, similar to what they did when they ratified the Constitution. Each state had to individually ratify them, and then as soon as 3/4 of them ratified, then that particular amendment was added to the Constitution as an amendment. And so 10 of the 12 amendments got ratified into the Bill of Rights. Kind of a little bit of a background of that.
Mm-hmm. Thank you, Don. Real quick, for everyone who hasn't joined us before, you should know that there is a downloadable version of the Constitution that is available to you. I'm sure Robin will be putting it in the comment section if you are watching this live. So please take a look there. If you don't see it yet, just keep checking back in, and you can click on that and download it and open it up, and you can read along with us. All right. Okay. So the First Amendment, we'll jump right into it, is I think most of us think First Amendment, we think freedom of speech, but there's a whole lot more in there than freedom of speech. So it covers that Congress cannot establish a religion. It cannot prevent the free exercise of religion. It can't abridge freedom of speech or the press. It cannot take away the right to peacefully assemble, and it cannot take away the right to petition the government regarding grievances. Well, that's a whole lot of different things. So what do y'all think of that? What stands out to you the most in all of that?
Well, I do think a key point of the First Amendment in any of the amendments is that over the last 225 years or so, all of these have been, almost every one of these amendments has been interpreted by the Supreme Court, and of course, all of them have been interpreted by the lower federal courts and the state courts. And at this point, we have a lot of exceptions written into the law through case law that don't exist in the text of the amendment, and it becomes a kind of a complicated assessment of what protections the amendments provide at that time. For example, there is the one that kind of makes me chuckle is that in the First Amendment, there's an exception for fighting words, but the fighting words case, historically was used to quell dissent specifically, but is generally, even though it is formally an exception in the case law, is not applied. There's been no recent case law probably in the last 80 years on the fighting words exception. So we have these exceptions that are not written in the text, but are created through Supreme Court case law, but even then aren't necessarily followed. They're primarily applied when a court is taking a results-oriented approach. And I think we see that a lot. The fighting words case, Chaplinsky, is really kind of a comical case. But we see this, and we would see this over and over with each amendment. I think that's a big issue that's easy to flag when we're talking about the free speech clause.
Mhm. Now, for our listeners who aren't familiar with the concept of case law, could you explain that real quick?
Sure. I'm going to take two approaches. I think generally when lawyers talk about case law, they're either talking about the opinions issued, the majority opinions issued by appellate courts. And frequently, the appellate court they care about is the United States Supreme Court, unless you have an issue of state law. But in the world of the Constitution, we're generally talking about, of the United States Constitution, we're generally talking about the United States Supreme Court. And so case law is the majority opinions that have been handed down by the Federal Court of Appeals, the United States Supreme Court, the state courts, Supreme Courts, and the state courts, intermediate appellate courts. I would also say, though, that, I think that even then it's only half of the question, because the trial courts, the majority of cases never proceed to an appeal. And the trial courts are what handle the vast number of cases. And so a normal person's interaction with the court system, a normal person's interaction with the First Amendment, for example, is going to be dealt with by a trial court and never reviewed on appeal. And so I think frequently we have to ask ourselves, what is the law? So in the context of the Bill of Rights, what is the law? Well, at one level, we have the text of the amendment. At another level, we have what the United States Supreme Court says, and the intermediate courts as issues work their way up, intermediate appellate courts. And then in the trial courts, where things actually happen to people, or I guess if we really wanted to drill down, although we're outside of case law, what happens with people like police and CPS, what happens on the streets. But I think when we think about case law, we think about what happens in the appellate courts, but also what happens to people in real life situations in the trial courts. And it can be all over the place. And so frequently, the issue is, in my day-to-day job, I say, this is what X law says, this is what the statute says, this is what the case law says, but this is what this judge will do. And it's very different, and people have to live with those consequences. So generally, though, in this conversation, I think we're talking about the United States Supreme Court case law. That's the most impactful, and it gets very detail oriented in the trial courts and the intermediate appellate courts.
Mm-hmm. Mm-hmm. I know when I read through this and I see something like, Congress cannot abridge freedom of speech or press. And then I think, well, we've got libel cases, we've got hate speech, we have all these things. To me, on just a basic reading of the Constitution, none of those things should be a thing, legally speaking. Now, would you say that all of those things are a result of Supreme Court case law?
Is that question addressed to me?
Yes.
Yeah. So a libel claim is actually it's a tort claim between private parties, but the First Amendment provides a defense because there's a federal court is limited, or really any court when you consider the 14th Amendment. But essentially, the First Amendment provides a defense in libel cases, but libel and slander, which in Michigan are called defamation, all existed at common law, so before the formation of the United States. The hate speech issue, there is the First Amendment protects hate speech. The fighting words exception, so fighting words are not protected. There's a number of other exceptions. Those exceptions, so for example, fighting words, child pornography, there's all these issues with fora. There's these issues with content versus viewpoint neutrality. All of this is the judicial gloss added by the Supreme Court to what the text says. So whereas the text says, it's very clear, black and white, Congress shall not infringe, the Supreme Court has taken a number of liberties to infringe and to allow people, largely police, to infringe.
Mm-hmm. Mm-hmm.
So what are fighting words?
Yeah. So in Chaplinsky's case, imagine Popeye. He did that boxing. Okay. So Chaplinsky was a socialist. In this case was in the 40s. So I think he got arrested in the 30s, and they would stand on these on the boxes. I can't think what they're called.
Soapboxes.
Under soapbox, yeah. So he and a friend were standing on his soapbox on the sidewalk, and a crowd gathered and started yelling at him, and which is called a heckler's veto in the First Amendment case law. They tried to shut down his speech, and the police, of course, agreed with the hecklers and attempted to arrest him. And as they were arresting him, Chaplinsky said something very 1930s-ish, like, just again, imagine Popeye. And Chaplinsky challenged his arrest based on First Amendment grounds. And of course, under the text of the amendment, he clearly should not have been arrested. And under today's understanding of the First Amendment, he should not have been arrested. But the Supreme Court, of course, didn't like socialists and wasn't concerned in this case with the heckler's veto, which is a doctrine that comes up over and over and over again. And so in this specific case, they carved out an exception for fighting words, declared that his words were fighting words, and that therefore his arrest was lawful despite the First Amendment. There has been no Supreme Court case dealing with fighting words since then. The closest thing is a case called Alonis from about 10 years ago, 5-10 years ago. It has to do with, it's called the true threat doctrine. So there's now a new exception called the true threat doctrine. But fighting words is only the Chaplinsky case. It is a case very much on its facts, and we would be laughed out of court if we ever tried to assert that as reasoning in an argument. But it's on the books.
Are they words that would potentially cause a riot, their potential violence?
He said something like, we'd have to look it up, but it was something like, I'm going to punch you, you pig, or something like that.
You see,
You dirty
trying to
scoundrel.
instigate a riot. Is that what the court?
No, it was that he was threatening to fight the police. So the police being the state actor at issue in the First Amendment. Yeah. So interestingly enough, right under First Amendment analysis, both before and after that case, the police actually they could either not get involved, or they actually have some duty to protect the speaker. Obviously, this isn't normally followed in America, which gives rise to a lot of First Amendment suits. But the idea is actually the speaker is supposed to be protected from the heckler's veto, and so the police there either would have had an obligation to not arrest them, or arguably, I think it's gray, would have had an obligation to protect them from the threats of violence that the crowd was threatening.
Yeah.
But it was a different time.
Mm-hmm.
So,
So the Supreme Court has muddied the waters with this issue quite a bit.
they have.
Then they've done, I'd say, the same thing with a lot of the other areas. It feels like the right to assemble has had somewhat of a similar treatment. when it comes to what is peaceably and what isn't peaceably and all that defining that goes in there. I know with COVID, we saw a lot of right to assemble conversations around the nation. Anything else that stands out to you guys as being particularly relevant in today's day and age for the First Amendment?
Well, Sarah, you bring up the peaceably to assemble, but it also does the opposite. It also allows you to exclude, to kick somebody out of the club, so to speak. So that's a protected right as well, to exclude.
You mean if they are a threat to the peace?
No, for any reason. We'll say somebody wants to join Convention of States, but they actually hold the opposite views. They don't have the right to assemble into our organization.
I do want to just push back on that a little bit, though. The first 10 amendments actually only apply to state actors and a related party, like an agent or a conspirator. And being that the Convention of States is a private party, the First Amendment wouldn't apply either way in a scenario like that.
Mm.
Yeah.
Mm-hmm.
So
Very
it would be
interesting.
more like the right to peaceably assemble does, kind of the common way we think of it as like a protest,
Mm-hmm.
which often those cases would be analyzed both under a free speech and a right to assemble analysis. But, in the newspapers, we would think of it, the right to peaceably assemble is often ignored in the public, but it goes hand in hand with the right to free speech or the protection for free speech.
So
Mhm.
who are the state actors then you're talking about in that situation?
Yeah, this is a great question. In today's world, so after the 14th Amendment and after a number of cases, including a recent case called Timms v. Indiana, the state actors are, and there's exceptions to this, and it will only make my blood boil, but basically it's government actors or like co-conspirators. So for example, the police is the most common one, CPS, public employers. So let's say if you work for a prosecutor's office, you have actually a First Amendment right. There are First Amendment and Fourth Amendment issues that come up in the course of public employment. But where we most often see these issues are with police officers. They are most frequently the executive doing the execution.
Okay.
Right?
Doing the infringing, is that what you're talking about?
Say that again.
Doing the infringing.
That's right. Yeah.
All right.
And I would also add, just to be like crystal clear in case anybody ends up in a jail, is that a police officer may have someone who's not employed. The government may have somebody who's not employed by the government, but is acting in concert. We would really kind of think of them as a co-conspirator. So for example, there could be, a current issue we have is security forces, private security. But if they work in league, if the police officers line up and they grab the security officers to all, for example, arrest a set of protesters, those security officers are now considered state actors.
Okay.
So this issue of state action, it's worth saying the issue of state action came up textually in the 14th Amendment. And then from the 14th Amendment on, the Supreme Court had a number of cases regarding the issue of incorporation, which, Don, I think you were mentioning earlier, in which the Supreme Court says that a right or a protection under the federal Constitution is incorporated against the state, which means the state is bound to that as well. And that happened through the 14th Amendment. As of about 4 or 5 years ago, all but 3 of the protections in the Bill of Rights were incorporated. And then there was a case, I think in 2020, called Timms v. Indiana. I think it was an 8-0 opinion, but it might have been 9-0, in which the Supreme Court said, of course, this particular right, which is the excessive fees and fines clause in the 8th Amendment, is incorporated against the states. So we can assume from the court's position that the remaining two rights have also been incorporated against the states, which means that it binds both the federal and the state governments. Although I think probably most of us have grown up understanding that in the background, that happened through the 14th Amendment and then the case law incorporating it.
So I want to just summarize my understanding of what you just said real quick to make sure everyone's on the same page here. So what you're saying is when you say this applies only to state actors, you're not saying that they're the ones protected by the First Amendment. You're saying that only state and federal actors can infringe on First Amendment rights. So if someone's going to say, for example, I can't take away my neighbor's First Amendment rights or stop their right to assemble. It would have to be someone who's employed by the government of the state or the federal government. Is that
That's exactly
accurate?
right.
Okay, perfect.
So you're
Okay.
saying universities can't.
A university like a public university like U of M or Wayne State, they are government entities, and so they can infringe on all of these rights protected by the Bill of Rights. Let me rephrase that. They would be in violation of the Bill of Rights if they infringed, and theoretically, there would be a lawsuit available. So to give a great example to maybe flesh this out, to circle back to the political speech issue, the Supreme Court has laid out different tests to kind of qualify what level of protection arises. And one of these is, what forum are you in? And so we have a traditional public forum, that's like a sidewalk. And we have a non-public forum, that's like a military base. There are no First Amendment protections on a military base, just whatsoever. And then there are, and I'm blanking on the word, but there are forums that are not public, that are made public. And so by practice, they become public and they have the rights like public forums. So for example, a public university when it opened its doors, its auditoriums were not necessarily traditional public fora. They weren't sidewalks, they weren't parks. But those auditoriums very quickly got used for things like debates and presentations. And in doing so, they became like public forums, like public fora. And so that forum gives an increased level of protection to a speaker, so that in today's day, so if we think of the University of Michigan, 200 years old, by now, every subject has been covered in every auditorium, which meant that the First Amendment applies to political speech spoken in those auditoriums. But if tomorrow we opened up a new college, new public university in Michigan, that auditorium would not yet have the same free speech protections as the one at U of M does.
Well, how do they get away with enforcing these free speech zones where you carve out areas where you can't enjoy your free speech rights?
Yeah, like at the airport?
No, at a university, they have free speech zones where you can only protest over in this one little corner, and no other protesting against this, speaker.
Yeah.
So it's free speech zones for some reason.
Yeah, it largely depends on what land a person's feet is on, and but let's assume. So, for example, to use the example of U of M, there's a lot of sidewalks there. All of those sidewalks, all of that grass is clearly a public forum. But once you go inside of a building, you have limited free speech rights. And this idea of designating where the speech can take place is, on the side of the government, the argument is, we've opened this place up, this forum, and so you have these great speech rights, you should accept it. But the argument of the speaker is that this is what's called a prior restraint on speech. And arguably, these free speech zones are not constitutional because they amount to a prior restraint on speech, and that's how they would be challenged.
Okay.
I laugh at the airport because if anybody ever goes to Detroit Metro and you go to pick up your bags, you will see that there's a little thing and there's a space for about 3 people to stand and protest. And there are not a lot of 3-person protests. It's absurd.
One last thing I want to point out, and then what I'm going to do is I'm going to cover Amendment 2 and 3 at the same time, is I think as a petitioning organization, I should point out that the First Amendment gives us our right to petition the government. So this is very important. What we're doing is very constitutional, and remember it. All right, so Amendment number 2 covers the need for people to be armed. It says a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Now, in that time and day, a well-regulated militia was not talking about a standing army. It was talking about armed members of the public. And obviously an important point here is that the reason why they wanted those members of the public to exist was to secure the free state. And that's pointed out right there. It's not so that you can keep yourself safe from a thief, although that's not invalid, but that's not what they point out here. It's that it's important for the security of a free state. And the Third Amendment covers soldiers not being able to impose themselves upon regular citizens, because that was a practice in that day and age, that when the militia would come through in a time of war, they would just set up living quarters in your house, and they would eat your food and so on and so forth. And so they specifically stated in Amendment 3 that could not be the way things were done, that the soldiers had to be, both in times of war and times of not war, taken care of in a manner to be prescribed by law. So that's the Second and Third Amendment. I'm going to go ahead and open those up for discussion.
So I'm interested in because we keep saying that it's an armed citizenry, but where does the term well-regulated come into play? Because we just can't just randomly let people, is that what they meant? Is just give everybody arms and no responsibility at all? Or what did the framers intend by the term well-regulated?
Good question.
I don't know if anyone knows the answer on this one, but that is it's like a term that was a contemporary term. I know a lot of historians write about this because it is frequently a question.
Mm-hmm. Of course, historically, we know the reason why bearing arms was so important to them was because Britain had come in and tried to remove arms before it wanted to smash their hopes of rebelling. And so that was a little near and dear to their hearts, was the ability to fight back, amongst other things. It's an interesting question. Yeah, go ahead.
I think one thing that's really interesting about current topics on the Second Amendment is that I can't remember either of the case names, but within the last, Bruen is the first case. And the second case, can't remember, but it was decided this spring. And we talked about judicial gloss on the first one. In the Bruen case, the Supreme Court held that the proper analysis of whether a gun restriction, gun regulation is constitutional is to take a historical analysis to see whether there was an analog at the time of the framing. And this was the Bruen case. And the Bruen case caused much consternation, so much so that federal judges who frequently do not badmouth the Supreme Court, there were a number of opinions in the trial court suggesting that this was a mess, that they didn't have the staff to hire historians, that a lot of public defenders' offices didn't have the staff to hire historians. And then about 6-ish months ago, maybe April, the court decided Rahimi, U.S. v. Rahimi. Rahimi was a case in which there was a very violent. There's a long history of violence having to do with guns. And the Supreme Court actually went back on its position that you have to take a historical approach. I shouldn't say went back. They limited this historical analysis, which means that as far as Second Amendment cases go, or really they often appear as defenses to criminal cases, that the Supreme Court effectively switched positions in the course of, I think, 2 years. And in that 2-year period, everybody was scrambling, judges, prosecutors, defense attorneys, to figure out what in the world is my ethical obligation to this particular criminal defendant in front of me, causing an absolute complete mess. And where the world stands today, it would be hard to advise a person whether a gun regulation is constitutional or not in the eyes of the nine.
Yeah.
Interesting. Well, some internet searches seem to indicate that and I'm saying this very generally because we know how much we trust the internet in random searches. So all warning there that a well-regulated militia had to do with well-trained armed citizens that could be called up to protect the state. So basically people who are disciplined and trained well enough to be useful in that capacity. Now, again, this is random internet searches. So, but that does make a certain degree of sense given the time frame, I think.
So if that's true, then is the government on the hook for training everybody to get weapons?
Well, it doesn't. It says that a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So the point of the Second Amendment is that because this other thing is important, you can't infringe this right. So it's not, at least from the way I read it, it's not saying that the government must ensure that there is a well-regulated militia, just that you can't take away this right that would allow this to exist. I don't know if you read that the same way, Sean.
For people to keep and bear arms, that's a contributing factor to a well-regulated militia.
Right.
Because I think they were arguing against having a standing army, which is another way of defending the states. Instead, this Second Amendment is leaning more towards, all right, we're going to let citizens own guns, but it still needs to be well regulated if they're going to have any value of defending a state.
Just to piggyback off that, it was the case that by the end of the war, Washington was opposed to a standing army because he saw it as, an oppressive form of the British government. But at the time, there were 13 colonies, and those colonies all gathered, their own citizens, right, gathered to fight. And so the idea of a militia at that time, and very much today, to some extent today, is that the militia were the people who volunteered to fight, but were not necessarily a standing army
Right.
of the whole country. And if you imagine, at that time, there weren't training grounds or bases or things like that. It was so that everybody, plenty of them were hunting or, any other kind of thing that might use guns. I think the Second Amendment, the idea was they were allowed to the guns were allowed to stay in the house. They couldn't be taken because of this need to keep a militia prepared.
Yes.
Yeah.
Mm-hmm. There's, and I'm sure from a financial standpoint with a new country, that's far more economical to just say, let's have all the people who want to be armed and ready, as opposed to let's have an army standing around and we have to pay for them and feed them and all of that. That sounds like a bit of a headache. Now, Robin, there was a comment that just came through. Could you throw that back up there? It's a quote, looks like a Madison quote. No person religiously scrupulous of bearing arms shall be compelled to render military service in person. Yeah, so I can see how that would be something. Well, I should say it's nice to know that they were considering that even at that time. I suppose the conscientious objections of people,
Exactly.
and the idea of whether or not people should be forced to participate. So
Yeah.
thank you very much for that, James. Appreciate it.
Sarah, you bring up the point about the cost, but there was also another consideration not to have a standing army, and that was the impact it would have on the available labor force. So, from an economic standpoint, cost aside, from an economic standpoint, the impact that a standing army would have on just, private businesses that didn't have these people available to work.
That's a great point. I wouldn't have thought of that particular angle, but that's true. You take that many people out of circulation, that's going to have a substantial impact on day-to-day business. Yeah. Especially
I'm
with
curious,
the way warfare was at that time. Yeah, go ahead, Tyler.
I'm curious of what your guys' thoughts are on the Garland v. Vanderstock case. It was the arguments were heard on October 8th at the Supreme Court. There's no opinion that's been issued yet. It's the ghost gun case, talking about whether a firearm piece that has not yet been basically manipulated to where it can be an operational part, whether that is considered still an operational part, like a receiver or something like that. I was wondering if you guys are familiar with that case and how you think that may possibly be ruled upon.
Yeah, it's an interesting case. Probably a pretty straightforward case, but an interesting case. Also, I don't think it's just so you're aware. I don't think there's a Second Amendment challenge. I think it's strictly a question of either statutory or regulatory interpretation. And the question is whether it fits the definition of a machine gun. And essentially, the argument by the company is that, well, it's not a machine gun because it's not a gun yet, right? Which, this is like the Perseus the ship kind of argument. And then the government's argument is that, but the only purpose of it, if it's sold as I can't remember what it's called, like a gun building kit or a gun hobby kit or something, that it's still functionally a gun with, I think the argument was about 15 minutes of work or 20 minutes of work. And so that's the competing question: is the Supreme Court is deciding whether it fits this framework of a machine gun.
Cool. Very interesting.
I would also say too, if I can add here, is that in different forms of so earlier, we use the word construction, right? How we construe something. So there are multiple forms of interpretation. So there's standards for the Constitution, there's standards for contracts, there's standards for statutes. And the Vanderstock case really puts a lot of tension between certain types of analyses that are forms of interpretation that are usually on the same side. So, for example, the company's argument is this very formalistic argument that because they're parts, they are not a machine gun. But usually formalistic arguments are on the same side as textualism and originalism. But when you read the statute or regulation, whatever it is, it really does seem like what they're describing is a machine gun, which means textually it's probably an easy case. And from an originalist standpoint, which has to look at the framers of that particular statute, or in the case of the Constitution, the framing of the particular provision of the Constitution, it really fits the machine gun definition from like an originalist perspective. And then there's often the other arguments, the other side of things, functionalism, pragmatism. Basically, everything is going against this company except for this very formalistic argument. And I think it's going to I'm honestly a little surprised the court took it up because it seems like, so for example, Justice oh gosh, I can't think of his name right now. But his name will come in a moment. But he's very much an originalist. But he also would have been on the side of Heller and McDonald in the Second Amendment cases, which means there's this Justice Thomas, which means there's likely this tension between how he would want to rule from a form of interpretation versus the party in which he normally sides with. So it'll be really interesting to see how people like Justice Thomas rule in this case. Another interesting person is Justice. Oh my gosh, why am I blanking on his name? The newer guy from Colorado, from the Ninth Circuit, but he's very much a textualist as well.
Alito?
So it would be, what's that?
Alito?
Nope. Young guy. I can't believe I'm blanking on his name right now.
Isn't it a K?
What's that?
Isn't it a K?
No, it's not Kavanaugh.
It's like right there.
It's the other one, yeah. But anyway, there's very much a tension between the forms of interpretation and the parties that they usually rule on. So it'll be interesting to see how this case comes out.
Well, let's move on to amendments 4 and 5. So amendment 4 is covering people's right to be protected against unreasonable searches and seizures and the need for warrants, to have probable cause, as well as there to be affirmation and specification of the places to be searches and the people and the things to be seized. So like a lot of limitations there on what warrants should be allowed to basically rope in. And then there's Amendment 5, which covers, I suppose, with law cases that a person can't be held to answer for a capital or infamous crime without being indicted by a grand jury. There is an exception for military type things, but they also can't be tried twice for the same crime. That's double jeopardy. That can happen. They can't be compelled to incriminate themselves. That's where we get the plead the fifth comment. They can't be deprived of life or liberty of property without due process. And private property can't be essentially confiscated for public use without just compensation. That's Amendment 4 and 5.
Where do we start? We've only got 13 minutes.
Yeah,
I
well,
know, right?
I'm interested in 4. What is personal effects and even papers? Would that be considered a document on the internet now? Could that be construed as papers in front of a judge?
I think that the Fourth Amendment the Fourth Amendment is always in tension with technology. This is a constant theme over the last 235 years. And the up until 1967 in United States v. Katz, the analysis in a criminal context was what was called the trespassery test. And so if there would have been, if a search or seizure would have been a common law trespass, it would have been unconstitutional. Now in 1967, the Supreme Court changed it to a reasonable expectation of privacy test, which makes a lot of sense. But even as recently as 2012, there was a significant analysis in a case called Florida v. Hardinas about the trespassery test, which then just kind of mentions the reasonable expectation of privacy test. But the key is that the reason why I bring that up is that once something is published on the internet, you have opened that up for everybody to see. It's the same as a license plate, right? A police officer may not be able to search the inside of your vehicle, but they can certainly search your license plate. And so once a document is published online, it really is almost completely likely to lose that security. I would say kind of an opposite example is I think earlier we were talking about the scenarios in which you could work for an employer who's a government, right? So let's say, again, you work for a prosecutor's office and you have a document stored on your personal laptop at work. And the government, the prosecutor's office breaks into your laptop and takes that document, even though you're a public employee and even though that laptop is at work, you probably have a good argument for protection. And so that's the distinction, is what you've disclosed outwardly is likely not going to be given protection.
Okay.
Yeah.
Interesting. Okay.
Yeah. Actually, you guys want to know, hear a funny quote from a Supreme Court case? I think it's Kylo. And Kylo had to do with a drone looking over a marijuana field in someone's backyard. And I think it was Justice Scalia said something like, made a joke about the heights of fences at the time of the framing, and said, well, if you could have built it like a 20-foot fence, you would have, and the police on their horses wouldn't have been tall enough to see over a 20-foot fence. He always has these funny little side comments. The Kylo case, super interesting in the world of the Fourth Amendment.
Oh, gosh.
Yeah.
Oh, that's fun. That's fun.
I would say, if I can add here, we were talking about judicial gloss and exceptions. There are approximately 20 exceptions to the warrant requirement in the United States currently. The most common one is the consent exception, but there are so many others that are referred to as exceptions to the warrant requirement. Then also, we would notice that it refers to this issue of probable cause, and probable cause is a common standard dealing with Fourth Amendment issues. But there's what you could kind of call an additional exception. It's not really an exception, but it's reasonable suspicion, which is a lower level of proof required than probable cause. And the way the court has gotten around this, so the seminal case is a case called Terry v. Ohio, which is where we get the term Terry stops. And the Supreme Court makes up some stuff that says, well, if you have less proof, you can still stop and frisk. The stop being the seizure, the frisk being the search. But since we are not saying it's a search, a stop, and since we're not saying it's a seizure and a search, it's constitutionally permissible as long as you have probable cause and as long as you don't exceed the scope that this reasonable suspicion gives you. Why this? So first of all, it's absurd. Second of all, why this really matters day to day is that stop and frisks are often used pretextually to find evidence of a crime, even though a search for evidence of a crime is not a lawful basis for a stop and a frisk. And part of how we get there is this term reasonable. You'll notice the term reasonable is used in the text of the amendment. And the court has ruled on a number of occasions, the most important being Graham v. Connor and Tennessee v. Garner. The Fourth Amendment is governed by a test of objective reasonableness. And in the law, objective can sometimes be helpful because it means that they should have known. It's almost like a community standard. But what this means is it's eliminated the subjective intent of a police officer when they do these things. So a police officer could do things pretextually. They could do things discriminatorily. And as a result, we have this pastiche of laws that say, essentially, a police officer can make up a reason, stop and frisk you, find evidence. They tell the judge, oops, I found this evidence. That evidence itself is now the probable cause. That probable cause, there's an exception to the warrant requirement. They can then arrest that person then and there. They can seize the items in most scenarios. And you can't do anything about it under current law. None of this is there in the text of the amendment. But it is how it works every day in the trial courts, every day.
Is that also the justification to be able to search an automobile, a car, if you have a traffic violation?
Yeah. So the way that police officers would do it lawfully and the way they commonly do it is that if there's a traffic violation, it's not criminal, right? And so without a crime, without evidence of a crime, they have no cause at all. So what they do is they will ask the driver or the passenger for consent to search. And it's always the line, well, if you don't have anything to hide, it shouldn't be a problem. And a person always says yes, and then they get searched, and then they find things. And as a lawyer, there's no basis for challenging it because the consent exception to the warrant requirement allows this police officer to get around this. So what we have frequently are pretextual traffic stops where something could happen something could happen. And I'm laughing at my most recent interaction with a police officer, and they will do their best to get in the car. And if you don't say no, they're probably going to get in the car. I would also say there's other ways they can get in a car too, but consent exception is the most common one.
So do you need to physically say, or I should not physically say, but do you need to actually say, I do not consent to be searched, essentially?
You actually don't need to say anything, but
okay.
If the police officer is following the law, they do need to basically request consent and truly understand it. But of course, if you choose not to speak, there's a big asterisk on this because of a case called Salinas v. Texas. But before Salinas, if you chose not to speak, you obviously had not voluntarily given consent. Yeah.
Okay. All right. Well, let's speed along to amendment number 6 and 7. And we might throw 8 in there as well. 7 is covering a right to a speedy trial. Sorry, I think that's funny. We don't get that anymore. A right to impartial jury in the district where the crime was committed. A right to be informed of charges. A right to be confronted with the witnesses that are accusing us, and our right to essentially compel witnesses of our own, and our right to assistance with defense. And then amendment number 7 covers basically what the value of a case needs to be to get the attention of a jury. And it actually says that controversies that exceed $20 should have the right of trial by jury. Now, I did do a little searching, and I found an inflation calculator. And according to the inflation calculator I looked at today, $20 at that time period is the equivalent of about $724 today. So that's a little inaccurate for today's world, but that was the general essence of that. A little bit more to Amendment 7, but I'll move right along to Amendment 8, which is dealing with bail, fines, and cruel and unusual punishment. We all know that there should not be cruel and unusual punishment, but we're also not supposed to have excessive bail, and we're not supposed to have to pay excessive fines. So that's kind of the 3 amendments 6 through 8.
I would jump in and just say the 6th Amendment is where we get all of the concepts behind the public defense system. All of that is the 6th Amendment.
Mm-hmm.
I got a question. What protects us from too speedy of a trial? Meaning that your trial date is set for the next day. So obviously you have no opportunity to prepare. So what in the Constitution protects us from too speedy of a trial?
So that would be the due process provision.
Okay.
Yeah, in the federal courts, that's the 5th Amendment, and in the state courts, that's the 14th Amendment. And how that comes up, how that would have played out many years ago, let's say 100 years ago, is that you may say, if we go too fast, I'm not going to have the time to investigate. I'm not going to have the time to review the police officer's evidence. I'm not going to have the time to file a motion. And this is a due process issue. And out of due process is where, so for example, in the federal courts, Congress has promulgated federal rules of criminal procedure. And those, and of course, the state courts have done the same. And that's where we get certain timelines. And so today, many issues, instead of us citing to the due process clauses, we cite to a specific court rule or statute. There's actually a Speedy Trial Act in Michigan that sets the dates for state cases. And so that's the tension between the due process rights of the defendant and the speedy trial rights of the defendant. Also, really super fun is that even though the Constitution doesn't exactly say this, and probably was not intended by the framers, but the speedy trial right is also a right of the people through the prosecutor, which means that if a defendant wants to slow things down for due process reasons, the prosecutor's argument is that the right of the people would be infringed by having a not speedy trial.
Well, what's the historical foundation for what were they trying to solve when they
Speedy
wrote
trial issue?
Speedy trial? Yeah. What were they?
Yeah,
trying
it was indefinite pretrial incarceration.
Was that just a common practice for a bad governor?
I would imagine so. I don't know if it comes up. It's never something we learned about specifically, but my understanding was that these were responses to the practices of the king. And also, I would say that this is actually a very real issue, and both at the federal level and in the state of Michigan level, these are serious issues being dealt with right now, where we have problems for everybody involved relating to intense pretrial incarceration. So what's interesting is that a lot of these issues arguably disappeared for about 150 years. And around like the 60s, 70s, we've seen an increase in pretrial incarceration to an extent that probably didn't really exist except for before the framing.
Yeah.
Mm-hmm. Yeah, I think I hear so many things about excessive bail and just years and years spent in prison before there's even a trial. And when I read the Constitution, I go, okay, we got a problem here. This isn't the way the process is supposed to work. Now, I don't know enough of the ins and outs to know exactly where the issue lies. I don't know if we don't have enough judicial judges. I don't know if we don't have enough judges in place to deal with the quantity just because our population has increased so much, or what really is the foundational issue here. But it's definitely something I can see our nation needing to address. George writes in, the Constitution defines the structure of the government. The amendments focus on the limiting the government's interaction with we the people.
Yes, sir.
Well, and Sean, you were mentioning something before we started streaming about the amendments going from the larger, how did you say it? The greater freedom to lesser freedom, something like that?
Yeah, this is just a thing I made up, but it helps me remember them. If you think about the amendments 1 through 8, number 1, this is what we would think of as like a well-ordered civil society, right? The First Amendment largely protects a person's rights to express themselves, right? The Second Amendment largely protects the rights of people domestically to organize a militia, right? The Third Amendment largely protects themselves from an army. The Fourth Amendment protects people from the police, which is where we really kind of begin the criminal process, is the Fourth Amendment. The Fifth Amendment covers kind of this scenario between the arrest and the filing of charges. So if you think about, the Salinas v. Texas case, which I mentioned, had to do with a guy in an interrogation room. There's a time between the arrest and the filing of the charges. The Sixth Amendment has to do with all your trial rights in a criminal case. The Seventh Amendment kind of makes an odd jump for a sec and talks about that anything that there was a jury trial right for a civil claim at common law, that jury trial right would remain protected. And then the Eighth Amendment deals with punishment and incarceration, which is the back end of a criminal case. And when you look at it from 1 through 8, it's kind of like we're looking at the most extreme forms of freedom all the way through the investigation and prosecution of a criminal case up until incarceration or punishment.
It's a good way to remember it.
Okay.
Yeah.
And kind of one like way that's really we think about is we frequently I know I'm so bad. So the Fifth Amendment, everybody's pretty familiar with this case, Miranda v. Arizona, where you have your supposed Miranda rights, which don't exist anymore, but no one wants to say it. And you have this right to be free from self-incrimination that's very textually located in the Fifth Amendment. But you actually have a separate right to be free from self-incrimination under the Sixth Amendment case law, even though the Sixth Amendment doesn't say it. But the way the courts have analyzed it is there's this pre-trial right, and then, or I should say, there's this pre-filing right, and then there's this right during the pendency of a criminal case against you. So you actually have two different freedoms of self-incrimination, even though the Sixth Amendment doesn't say so. And that's, because we're seeing it move through like the stages of an investigation.
Very interesting.
Well, if we jump into the 9th and 10th Amendment real quick, the 9th Amendment says the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. And I would paraphrase that to say that if there are rights that we haven't said you have, well, you still have them. It's just that they are in the jurisdiction of the people and of the states, not of the federal government. And then Amendment 10 says the powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people. So it's saying the same thing as the 9th Amendment. Instead of focusing on the rights of the people, it's focusing on the powers given to the government. And it's saying that if we haven't said the federal government has this power in this Constitution, it belongs to the state and the people. So 9 is dealing with the rights. If the federal government doesn't have them, the states and the people have them. The 10th is dealing with the power, and it's saying if the federal government isn't said to have it in the Constitution, the states and the people have it. Kind of nice little wrap up there, huh? All right. Any last thoughts? Good conversation.
Well, Sean, you have any history with the Darby case? I don't know, the 40s about and I had something to do with the 10th Amendment, and the judge, the Supreme Court justice, basically ruled and said, because they tried to use the 10th Amendment and defend themselves, this Darby case, whatever it was. And the Supreme Court justice said, oh, the 10th Amendment, that's but a mere truism.
Yeah.
So just wondering if you might have learned that in your studies.
I would say that the 9th, 10th, and 11th are, the 9th and 10th are almost so much in the background in the litigation world that they almost never come up. And the 11th Amendment is pretty much in the background unless you don't know what you're doing and you make a mistake and you file the wrong case in federal court. So there are these issues with 11th Amendment immunity that come up from time to time in constitutional litigation, but a lawyer tries to avoid them. But so much so that the 9th, 10th, and 11th become like background. They become like the story, right? Not like a useful, not like a thing we would cite.
Yeah.
So they're important to know, and they're also important to keep track of separately, because they all say slightly different things, but they are making the same point.
Well, I want to say thank you to all of you who have been joining us online. Thank you for sticking around this long. If you have enjoyed this, please join us next Tuesday at 7:30, same place. And we will be discussing the final amendments of the Constitution. We're going to wrap it up. Amendments 11 through 27. Again, that's Tuesday, October 22nd at 7:30 p.m. Join us. You can use the QR code on the screen to download your pocket Constitution. Let's go ahead and close in prayer, and we'll get back to our evenings. Father, we thank you for the opportunity to have these conversations, and we ask that you'd be with us and with all of our viewers as we go out throughout the rest of this week. You'd give us wisdom, that you'd give us insight, that you'd show us how you would have us work in our nation to make it a better place. We thank you and we praise you. Amen.
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 All right. Have a wonderful evening, everyone.
Have a great evening.